Okay.
Eliscati Bumena? Eliscati Bumena?
Hello, I'm Andrew Elenas. This is Pharos TV. And if you're an expat living here in Cyprus, then I think this may well be of interest to you. I'm joined by Wayne Barnett from Maple Book Services, who's colloquially known as Wayne the Will Man, for a very good reason. And one of the most important things that you need to do when you come into Cyprus is make sure that you have a Cypriot will. Wayne, why is that so crucial?
Well, wills are a document which enable people to be able to distribute their assets after they've passed away, detailing who is going to receive what and what kind of timescale. There are a number of issues as to why a Cypriot will is very useful for a British expat. Firstly, in 2015, legislation was brought in Cyprus called forced heirship, where people lost the ability to distribute their assets in the way they might wish. There was a fixed formula. However, people of non-Cypriot nationality are able to opt out of this system. The system was brought in throughout the EU, and out of all the EU countries, 3 opted out: the UK, Ireland and Denmark. Ireland and Denmark opted out because they already had a system of how assets should be distributed after somebody's passed away. But the UK allows you to distribute within boundaries to whom you want. So the first thing is that if you haven't got a Cypriot will, which mentions that you're relying on, for example, British nationality or South African nationality, then your estate will be distributed in accordance with Cypriot law. By putting in this particular paragraph, which we refer to colloquially as Brussels 4, we are able to allow people to distribute the assets basically to whom they want.
What is a will, and how do we go about creating it? What do we actually have to do? Can anybody write it, or does it need to be written up by a professional?
You can buy, in the UK, you can buy wills at stationers, etc. It's a very poor decision. There are so many quirks and problems that need to be addressed by somebody who's an expert in the production of wills. And even in the UK, local solicitors, they may be general practice. They're not dealing with wills day in and day out. We at Maple Book Services have that expertise. We're qualified, we're registered, we've got professional indemnity insurance, and we're expert in providing the correct advice at an appropriate time.
Is there a particular difference between a will that's been created in the UK and one that's been created here in Cyprus?
Wills in Cyprus are totally different. Firstly, they have to be loose leaf, as opposed to bound, as an English will would be. Secondly, all wills have to be signed on every page and witnessed by 2 people. Thirdly, they have to be signed in blue ink. People ask me, why blue ink? And I believe the reason is that the legislation on this was brought in before the advent of colour photocopiers. So if it's in blue, it had to be an original.
What are the sort of common clauses that people put into their wills, and what are some of the pitfalls, perhaps, that people might fall into if they don't get proper professional advice?
Okay, the average client of mine is in retirement, probably second marriage, and maybe each partner has 2 children from previous relationships. So they own a house jointly. They want their partner to be able to live in that house after they've passed away, but eventually they want their half share of the house to go to their own children and not necessarily to the partners. If they just leave everything to the partner, they may have originally prepared wills leaving it in 4 quarters to each of the 4 children, but there would be nothing to stop the surviving partner changing their will. I had a situation where a lady asked me to write a new will for her, and she said, we originally agreed to leave our assets split equally between the 4 children. However, my husband passed away, His children have been absolutely obnoxious to me. They've been revolting, and I'm changing my will. I'm excluding them. And I'm sure that's what my husband would have wanted.
And of course, under those circumstances, there's nothing that can be done about it.
No, except in the UK, apparently up to 25% of wills are now being challenged for scenarios such as this. People feel they've been reduced in their inheritance, or they haven't received anything. So sometimes it goes to court, and generally it's the lawyers who win most out of that.
As they usually do. Can that happen here in Cyprus?
It can happen in Cyprus. There are cases where people have excluded, for example, their wife and left everything to their child. And the wife can take action in the court here if the person was deemed to be domiciled in Cyprus. And accordingly, in that situation, they would have to take over the law applicable to Cypriots born in Cyprus.
We often hear when people are talking about wills that they've appointed executors. And it sounds like this is the sort of person who actually has some control over the distribution of the estate. Is that the case?
Generally, the executor is working according to what is set out in the will. Executors are people who are appointed to collect in all the assets, administer, calculate any liabilities, debts, whatever, and eventually apply for probate here in Cyprus, and after being granted probate, to distribute the assets in accordance with the will. Here in Cyprus, it often takes an inordinate amount of time to get probate. And I'll come on to what probate is in a second, but it's the actual definition and release of the assets by the government. But it takes possibly 2 years. I once had an interview with a Cypriot lawyer. I was talking about English probate, she was talking about Cypriot probate, and I asked the question, I knew the answer, but I wanted listeners to hear it. What's your longest probate? And she said it started in 2008 and it's not finished yet. Where you've got, for example, British people living here and they apply for probate, the government here will want to know that they don't owe any income tax or social security. If the person hasn't been filing a tax return here, that's going to cause an issue because they just don't know. So what they do is they write to the Inland Revenue, HM Revenue and Customs in the UK, and ask for a certificate of residency, i.e. where the UK Tax Authority believes this British person should be taxed. HMRC in the UK, they're not particularly enamoured to receive posts from the Cypriot tax authorities. They don't prioritise it, so it takes about 5 months apparently before they respond. And sometimes they don't even send a certificate of tax residency, they send a confirmation, which is unacceptable to the Cypriot tax authorities, so they write back again. So probate can be delayed substantially by just tidying up affairs. If, for example, HMRC in the UK said, we accept this person as Cypriot tax resident, then the authorities here will probably ask for the last 6 years' tax returns to be filed. So the executor has to go through the person's paperwork, extract all the information about their pension and any other income, and supply tax returns for the last 6 years to demonstrate that there is no tax liability here. So probate can take an awful long time.
And it sounds like it's quite a complicated and long-winded process. So who would normally carry that out?
Okay. What normally happens is that we suggest that a family member or friend be appointed as executor. However, to be an executor, you have to be resident in Cyprus, and a lot of the forms are in Greek. So what we normally do to assist clients, and we were doing 2 of these today, we enter into what I call a beauty parade. We contact 3 or 4 firms of lawyers here and say, unfortunately, a client of ours passed away. This is what's in the estate. What would you charge to do the probate? The lawyers here insist on knowing what's in the estate before they quote, because it does affect their own professional indemnity insurance, so they need to know what exposure they have. So they will come back with a quote. And generally, we're talking about probably in the region of 1 to 2% of the estate, maybe 5,000 euros.
That could be a lot of money. That could be a lot of money. If somebody's got a nice house here in Cyprus, that could be quite a substantial amount.
It could be even more if you generally appointed a lawyer who's entitled to charge according to the table set by the bar, because that percentage is between 5 and 7% generally.
7%?
So it could be 1/12 of the estate of the person that's passed away. So generally it does make sense to appoint somebody, do a beauty parade, get a competitive tender, and then choose the firm that you're happy with and appoint them. The person who's appointed in the will renounces their appointment in favour of the firm of lawyers that they've chosen.
And in fact, it'd be a good idea if you've got an existing Cypriot will to contact the lawyers that you use to make that will to find out what their charges are going to be, because you don't want to end up with 7% of the estate going.
Absolutely. And very often what you might be able to achieve off of the lawyers, if they know you well, is they may give you a price in writing now that it won't exceed so much, and that's wonderful. I have had scenarios. I had one lady had an estate worth €1 million. She had no children, nobody to leave it to, so she was leaving it to charity. And I said, I think you should check from your executor what they would charge to carry out the probate. And this lady said to me, don't be silly, she knows it's all going to charity. I said, I'm sitting here, you're sitting there, phone her. And she did, and the response was, we charge according to the table. Well, that could be 5%, that could be 50,000 euros plus VAT. An enormous amount of money that the charity didn't get.
Is there any difference in the sort of will that needs to be created for somebody perhaps who comes here on holiday? I think they're called swallows, aren't they? They fly in and fly out. A lot of expats do that, particularly now after Brexit. Is there a difference in the sort of will that they need to have?
It might be a bit simpler because they have maybe reduced assets in the area, in Cyprus. But the principle is the same. They need a will to ensure that that property is distributed to the people they want, and avoiding excessive probate charges.
And is it possible to have one will that covers both UK jurisdiction and Cyprus?
Very good question. There is such a thing as an international will, or often referred to as a worldwide will. Generally, we don't recommend it. The issue is that you have to go for probate, let's say in Cyprus first, before you can even start the probate process in the other country, say the UK. So, as we mentioned a little earlier, probate here could take 1 or 2 years. It would be a nightmare not to be able to start the probate process in, say, the UK for a couple of years in order to access bank accounts, investments, etc. There are situations where we've done an English will which covers an account in Jersey. There may be, or the Isle of Man, for example, there may be, say, £10,000 in one of these other jurisdictions, and perhaps it's not necessary or cost effective to do a second will for that small amount. The UK generally probate takes 8 months, so if somebody waits 8 months before they access the last £10,000 in an estate, if it's a large estate, that might be an economic decision. But generally we do recommend a separate will for each jurisdiction. We have contacts with lawyers in Ireland, Jersey, Guernsey, the Isle of Man, and even in France. So we're able to assist clients with connections and lawyers in these jurisdictions.
One of the other things I wanted to talk to you about was, as people are getting older here in Cyprus, sometimes, unfortunately, mental capacity becomes an issue. What is the legalities around the mental capacity for people as they make a will? Somebody who's got Alzheimer's, are they able to sign a will?
No, they're not. One of the things that we do is we assess each individual client as to whether or not they have the mental capacity to sign a will, whether perhaps they're being coerced into distributing assets to certain people, whether they understand what's in their estate, whether they understand who should be potentially entitled to receive a bequest from the estate. So all of these things, it goes back to a case over 150 years ago in the UK called Banks v Goodfellow. And so we get people to discuss these particular subjects. We assess and we make a note on our file as to whether or not we consider that person had the mental capacity to be able to enter into a will. If there is such a challenge to a will, then we're able to produce our file to show that on that day we've made notes as to somebody's suitability, to somebody's ability to enter into a will, that would go as evidence in such a case. We have no axe to grind. We're not benefiting from anything. We're not even entitled to receive a bequest under a will that we create. So we just want to make sure that the client's wishes are honoured to the best of our ability.
So if you're writing a will for somebody, do you actually have to make the judgment call as to whether you think that they are mentally competent enough to be able to sign it?
Absolutely.
How do you do that?
We have certain sort of conversation scenarios that we enter into to see whether somebody understands what we're talking about, what they're thinking about, what they're deciding, etc. And so we make a note and a record of all of those. I have had a situation a couple of years ago where I was asked to go and see a lady by a carer. And this lady was very wealthy, had many millions, and the carer had torn up a piece of A4 paper into 10 pieces, and each piece represented 500,000 euros. And she was trying to get the individual, the client, to agree this 500,000 should go to this charity, this 500,000 should go to that charity, etc. 3 of the pieces of paper had the carer's name on. I was unable, I actually took someone else with me as sort of a double scenario, and we both came to the conclusion that this lady did not have sufficient mental capacity to distribute and create a will, distribute her assets and create a will. In that event, what's going to happen is that the lady will die intestate. Intestate means didn't have a will. And then the system kicks in, and the people who are administrating the estate will look for relatives. And in this situation, this money, as far as I'm aware, will go to nephews and nieces in another country who have no idea of this lady's existence. So it's difficult.
Now, there are circumstances, aren't there, where you can be living in Cyprus and you can then lose control of your assets in the UK. Now, that's, I understand, is a lasting power of attorney, and I'd like to talk to you about that in just a moment.
Okay.